Do you have to possess the legal knowledge necessary to maneuver through a complex litigation in order to represent yourself in an Oklahoma criminal case? I'm Tulsa Attorney James Worth, and that is the question that we have, and it's coming up from a relatively recent decision from the Oklahoma Court of Criminal Appeals, Alonzo Kelly v. State of Oklahoma, 2023 OKCR 2-1. And that is a criminal case that was here in Tulsa County, went before Judge Sharon Holmes, and the defendant made a request to represent himself in court. And Judge Holmes asked some questions, determined that he did not understand the complexities of criminal defense representation, and denied him the opportunity to represent himself. And he had court-appointed counsel represent him instead. Ultimately, he was convicted, and he appealed his conviction to the Oklahoma Court of Criminal Appeals. And the primary error that they brought is that he was denied his right to self-representation. And the Oklahoma Court of Criminal Appeals agreed with him and actually reversed the convictions and remanded it back to the trial level for him to get a new hearing where he can request the right to represent himself and have a proper FREDA hearing for that. So, what are the rules if you want to represent yourself in a criminal case in the state of Oklahoma and elsewhere, because it's based on U.S. constitutional law? Well, let's see. It says that this court reviews the totality of the circumstances to determine whether there's been a valid waiver of the right to the assistance of counsel. Okay, the factors considered when making the determination are: 1, whether the defendant was competent to make the decision; 2, whether the request for self-representation was clear and unequivocal; and 3, whether the defendant knowingly and intelligently waived the benefits of counsel after being informed of the dangers and disadvantages of representation. It's important to note, no particular knowledge of the law or courtroom procedure is required. You don't have to know the rules. You don't have to know the evidence code. You don't have to know any of that in order to represent yourself. You just have to be competent and understand the dangers, and then unequivocally make that request to represent yourself. Generally not a good idea to do so. I mean, if I'm going to provide legal advice to somebody, my first advice to them is don't represent yourself. Get an attorney that is competent and has experience in this, and also somebody who has an outside view of it, so they get a better idea on how the judge might look at things, how the state prosecuting might look at things, and also how a jury might look at things. If you're on the inside from these allegations, you don't have that outside perspective, it can be more difficult. And of course, not understanding the laws and the procedures and the evidence code. It's not required that you understand in order to represent yourself, but certainly you're at a disadvantage under those circumstances, so you probably don't want to do that. But in this case, the court found that just because he did not understand those rules does not mean that he properly waived the right to assistance of counsel, and that he does have the right to represent himself. And it says further that, rather as noted above, the trial court denied his request upon a finding that Kelly did not possess the legal knowledge necessary to maneuver through a complex first-degree murder trial. That is not the appropriate test, is what the court is saying. The test whether the defendant has intelligently elected to proceed pro se is not the wisdom of the decision, which it's not wise, or its effect upon the expeditious administration of justice. It is only necessary that the defendant be made aware of the problems of self-representation, so that the record establishes that he understands that his actions in proceeding without counsel may be to his ultimate detriment. And that is under, as I said, Ferretta versus Oklahoma, 1975, United States Supreme Court case. The defendant's technical knowledge of the law and its operation at trial is totally irrelevant in the assessment of his knowing exercise of the right to defend himself. Right, so that is the law as it stands based on Supreme Court precedent. You don't have to know the law to represent yourself. You just have to be competent and understand the risks and waive having appointed counsel to represent yourself. If you're going through a criminal case in the state of Oklahoma, though, I very much would recommend that you do hire counsel to represent you. You can talk to many different ones to interview them, find out who is best for your circumstances. If you'd like to talk to an attorney at my office, you can go online to makelawEasy.com.